And we are live. Happy Friday, everybody. Welcome to another weekly. I didn't do last week because I was in India, but that's a good excuse, right? But otherwise, weekly, regular Friday chat. And I'm very excited to have Eduardo, who I always enjoy hearing, learning, seeing, dining with. I think most of my audience knows of Eduardo Ustaran as one of the leading global privacy and AI and digital governance lawyers at Hogan Lovells. And we're going to jump into a topic that has people angry, confused, befuddled. And I'm among them. I'm on the befuddled side. I'm not angry. I always figure that, I've been like you doing this a very long time as a global chief privacy officer in the think tank world. And I may not be the smartest person in the room, but I have a general history and understanding of data protection laws around the world and data flows. And when I learned that something that I thought was the case from the law, from interpretations, from wide industry practice, from top legal counsel, from views from regulators for 20 plus years is suddenly no longer the case. And I've been wrong all along. In fact, we've all been wrong all along. It undermines my kind of respect for the, integrity and the quality of the, the thinking and the analysis. So this is one of these examples. I always understood the BCR processor to specifically be used for the purpose that the EDPB is telling us without any big announcement even, like we're making a major change in policy. All of you who've been using BCR-P in this particular way, you're all wrong. Don't do it like that anymore. You shouldn't have been doing it. Maybe you were violating the law. Like there's a major policy decision, probably one that should be made by the legislature, that it looks like the EDPB is making by very significantly narrowing the way BCR-P can be used. Okay, so before I confuse everybody with my confusion, can you set the stage here and tell me, was I just confused all along? I didn't know what I was talking about as a chief privacy officer. The other regulators who took the view that BCR-P could be used in this broader way were confused. The Article 29 Working Party was confused. I was going back and reading. I just printed off some of the announcements from the early 2018, the early announcements about the, here it is, 2013, the explanatory document from the Article 29 Working Party. And they said, we're updating the BCRs specifically now because our old update didn't do enough to cover outsourcing processing activities to sub-processors, given all the cloud, all the globalization, all the data centers. I'm reading I'm like, maybe I didn't know what I was talking about, but I'm reading the language that this was the purpose. What is going on here, Eduardo? Help me understand.
Okay. I think we need to remain optimistic. And by that, I mean, we need to first bear in mind that this is a consultation, so there is room for dialogue. And I think it's important to appreciate the sense of what you are saying. You are, of course, referring to binding corporate rules for processors, which have been in GDPR, but were created even before the GDPR. And the idea behind BCR as a whole has always been to allow corporate groups to transfer data globally within the bubble of that the BCR create, so that it didn't matter where in the world the data was going to, but as long as it was within this group and within the management of the BCR, it would be regarded as safe. That was the concept. Originally, it was just for controllers, and a few years later, it was introduced for processors. Of course, processors are in a different position from controllers, in the sense that processors only exist to interact with their controllers, with their customers. So, of course, the real value of processor BCR has always been the ability of a controller in Europe giving the data to a processor anywhere in the world who was providing the BCR protection, and therefore that controller would be safe, or the data that belongs to that controller would be safe anywhere in the world. And I have to say, I am guilty for the introduction of this concept. I remember probably 2009, 2010, walking into the offices of the CNIL in Paris in order to sell the concept of processor BCR, because controller BCR had been quite successful for a few years. But of course, the appeal of the processor BCR from a practical perspective was very, very large. And many organizations, many vendors were hoping to benefit from that. That has been the case. Leading service providers of technology services have been rushing to adopt and get approval for processor BCR. As with the case of the controller BCR, the EDPB decided to, let's say, modernize the concept, and essentially to add requirements so that the processors that abide by their own BCR need to, I don't know, step up the standards. But the challenge that these new recommendations that were introduced at the beginning of this year, draft recommendations, so under consultation, is that the EDPB, in a sort of casual way, have said, but remember, processor BCR is just for intergroup transfers. So the transfer needs to happen from a processor in Europe to a processor outside Europe. I think that there is room to rethink this way of approaching process. This is a very analog way of looking at how data transfers work in the real world. There isn't anymore a linear transfer that the data sits in one place and then very, very quickly or very, very slowly is transferred to another place geographically, as if it was flying on an airplane or sailing on a boat. Data is everywhere. That's the essence of cloud computing. That's the essence of the internet. So it becomes irrelevant to say, oh, the controller is in Europe, but the processor is not in Europe, and the processor has to be in Europe in order to benefit from this processor BCR concept. Ultimately, what matters is what happens to the data when it's in the hands of the processors. And I think most regulators will understand that it doesn't really matter whether the legal entity that is transferring the data is a processor based in Europe or indeed a controller based in Europe, because ultimately the data is emanating from Europe to outside Europe. So I think I would play down a little bit this statement made by the data protection authorities. I would emphasize the fact that ultimately the benefit, the very commercial benefit of BCR, is to allow a processor, a service provider outside the EU, outside the UK or Switzerland, to benefit, to provide that benefit to the European customers. And I think that will continue to be the case.
Yeah. I mean, look, I understand.
Does that reassure you?
Look, I understand if back in the early creation of the concept, if someone had said, this is a concept for transfers within one company, do you really need agreements? And I remember, and frankly, people who haven't had the BCR approval process have, and I remember signing these contracts and I thought it was ridiculous. I'm signing a contract between Division 1 of my company and Division 2 of my company. We're like, we're the same company. What are all these intercompany, agreements when we're sitting on the same, network even? And so it made sense to recognize that companies that go through the BCR approval process and who are audited and who are living up to the requirements, that we can rely that the requirements of GDPR are flowing through the company, instead of having standard clauses with different corners of a company as if they're going to sue each other or leverage the contractual rights against each other. But when I think you raised this issue back with the CNIL, and when regulators were looking at the complexity, this was a practical data protection and policy decision that was made. And it just seems like there's a number of leaders at the staff or DPAs who either don't appreciate the consequences or are looking to make a very big policy decision about international data flows by pulling back this guidance. But I would imagine that the way to do this, if one wanted such a major change, would be to refer to the early guidance, explain what's changed somehow because of GDPR or transfers or so forth, give us some sort of analysis that we can understand and debate and discuss. It just seems like a very casual, backhanded change of direction. I mean, maybe some DPAs always thought this, but clearly this was not the majority opinion. Now, the UK, for instance, right, has quite clearly gone in a very different direction. Any more we might, and I assume we'll go in a different direction in this case as well, which obviously will complicate life for many in Europe.
Yeah, I think the UK has always accepted the value of BCR in the way in which we're explaining. And I think the EDPB will as well. I don't think that this is a policy decision, a deliberate policy decision to change the law. I think it's just perhaps a narrow interpretation of of the concept. But I think we need to remind ourselves, and of course remind the regulators, that the whole idea of BCR is to raise the standards of protection for the data. BCR are not needed in the law, in the sense that it's an option that companies choose to adopt. But if everybody knows that BCR are seen as the gold standard of data protection, of global data protection, if there is a great export, if you want, in terms of data protection from Europe to the rest of the world, in addition to the GDPR itself, is BCR. Because BCR is a way in which a company, an organization, and we are talking sometimes of some of the largest organizations in the world, some of the largest companies, are deliberately deciding to apply European data protection standards globally. That is a gift to European data protection authorities. That is making their life a lot easier. So I think they understand the value of that. And I think it's a matter of explaining that. In the same way, there is a big commercial value. Those companies that do that are not saying, oh, how can we make our life much more difficult in terms of compliance? Let's just adopt the most rigorous standards applied globally. They don't do it for their own satisfaction. They do it because they want to present themselves in front of their customers, are saying, you want to serve the best protection, we provide that. And the gold standard for the protection of personal data is what we are doing and what we are meeting. And I think that value can be also understood by the data protection authorities.
I was in India last week for the big global AI Action Summit, and many regulators were there, and spent a lot of time with many of the senior Indian regulators discussing their Data Protection Act, their regulations, their focus on AI. And they very much had the perspective that although they had started out in their data protection journey looking to Europe, they had gotten the message that if they want to compete in the global AI marketplace and be a major, processor and a major data center hub, that the European approach didn't have the flexibility needed. And I spent some time explaining how we were starting to see, indeed, some creativity and flexibility and, careful thinking of how GDPR could have flexibility to recognize AI training, and how, of course, there were even, the ongoing omnibus debates and so forth about areas where one would apply more flexibility. It just seems that this is a step at a time when we're seeing most of the regulators recognizing that there are societal values that are important, that always need to be protected. And then there are places where one can be pragmatic in order to also support both the social benefit along with the protections that are needed. That this is sort of a retrogressive step, if indeed it would go in that direction. So I'm heartened to hear that you think that this is sort of still very much up for debate. But let's talk about where the world is going, since you do practice globally. It does seem like there's been a new energy and a advance in the general global cross-border data protection rules process, the CBPRs. I know you're going to be in Peru for the important convening of the countries that are debating and discussing and expanding the global CBPRs. What's your take? Am I right that there does seem to be new energy, new members, new understanding that this is a framework that is critical for much of the world, including Europe, in terms of interacting, with it? Not everybody is going to be adequate, even in the most glamorous sense of the word. There are jurisdictions, there are democracies, there are non-democracies, and we're all managing somehow to do business together. So clearly, many of those countries, will never be adequate. That there needs to be both a decent model for credible transfers. What's your take? What are you looking forward to see happening in Peru and in the broader debate here?
Yes, the Global CBPR Forum initiative is perhaps a sign of hope for the world. We need a lot of signs of hope for the world right now, and I think this is one of them. And I say that, of course, because I think CBPR as a mechanism is gaining momentum, if you want, and that's for a number of reasons. The concept itself, in a sense, you could treat it as a BCR light, if you want, and maybe there is a lot more nuance to the concept than just seeing it as a BCR light. But essentially, it's not very dissimilar, because it's a set of rules and standards that companies decide to adhere to voluntarily, and they get certified for adhering to these standards. So it's a similar concept in a way. The difference, the specific content of the whole geography around CBPR is much wider, much more diverse than Europe, because it was originally sort of devised amongst the APAC countries, and ultimately it's still sort of, in a sense, run by that. But in fact, the U.S. Government, that sometimes has, or in recent times, has been less perhaps keen to be involved in international processes or international organizations, is indeed very interested in injecting a good degree of goodwill, if you want, in terms of the idea. And I think the reason why I think it is now important to be involved and to pay attention to this is because, and the reason why I'm going all the way from London to Lima to to be part of this workshop on this project is because I think there is value from a European perspective in looking at CBPR, perhaps as, at the very least as a stepping stone into BCR, but also as a model that could one day perhaps have recognition even in Europe as a mechanism for international data flows, is again from Europe. And of course the UK is it's a European country with the same standards in terms of GDPR data protection standards as the EU, which is becoming more and more involved in CBPR. So it's a model to pay attention to, perhaps not too dissimilar from BCR, but more global in mindset, perhaps, and perhaps a little bit more pragmatic in the thinking behind it.
Yeah, I will echo the fact you're sitting in London, I'm sitting here in Washington, and obviously figuring out the US government's global trade and global strategy on lots of issues can be also quite complex. And it is, however, quite the case that the CBPR process is a huge political priority, and we see the State Department, the Commerce Department, senior leaders in government looking at this, despite some aversion to global cooperation sometimes, under the UN or under other mechanisms where there's been criticism. Well, that's bureaucrats telling us what to do. We don't want to be restricted. We want to win, win, win. When it comes to the CBPR process, I think there's been very thoughtful recognition that cooperation and collaboration and promising adequate levels of protection are a benefit to individuals and companies. In the few minutes we have left, let's touch a little bit more on the direction of the UK, which, of course, as you mentioned, as a GDPR adequate country, as a country with a GDPR version of a law, with a significant ICO. People can always argue and debate, is the ICO doing enough for this and that, but sophisticated team, lots of analysis, lots of global cooperation. There are DPAs that don't have those sorts of resources or commitment many places in the world. The UK team is intellectually and legally and very practically engaged. How do you see this sort of position where the UK clearly plans to be part of Europe in all the economic ways, but also is ensuring that it's part of the world, part of the US relationship, part of the economic AI leadership debate, and in some ways showing that there are ways to bridge these two different framings?
Yeah, the UK is definitely one to watch in the sense of what's going on in the UK. I think continues to be very influential in the world of data protection. And I say that because at one level, the UK is a very stable jurisdiction in terms of data protection because it has followed the same philosophy in a way that very much aligned with the rest of Europe, but in a very pragmatic and sensible way, I would say. But more specifically, these days that we talk in Europe a lot about the digital simplification. Well, data protection simplification happened in the UK last year. It was, again, a relatively andromic simplification in the sense that not many things changed. But one subtle change that was made to the UK data protection law was in relation to international data transfers, and more specifically to the provision in what is Article 45, I believe, of the GDPR, which is the one about adequacy, which of course the UK is able to declare other countries adequate. But the criterion in order to determine whether another jurisdiction is adequate for international data transfers is no longer what used to be called, and still is in the EU GDPR, essential equivalence. So it has to be essentially equivalent to the GDPR. In the UK, in the new Article 45 of the UK GDPR, it is about the law of the other jurisdiction not being materially lower. So you could say, is there much distinction between essentially equivalent or not materially lower? These are just lawyers being lawyers and being very picky about it. You could say that, but ultimately is also the spirit of what is behind that change of wording. And again, it's a subtle change, but the spirit is, look, we are not expecting everyone to be trying to copy us. What we expect, or what we regard as good enough, is that it's actually not, it doesn't devalue what we have, and it's not materially lower. It's not in any significant way worse than what we expect. And I think that is the philosophy that informs a lot of the thinking in UK data protection law and in terms of international data transfer. What that means in practice is that at the moment, the UK and the EU are virtually identical in terms of adequacy determinations. The EU is ahead because the EU has declared Brazil adequate and the UK has yet to do that. Rest assured that I don't think we'll get to the end of this month before the UK does that. But then once we get past that point, what I can see the UK is trying to do is to get ahead of the EU and say, well, once you think about which jurisdictions are adequate, we have already decided that this country and this country, their law is not materially lower to ours, and therefore we think they are adequate. And we may see some discrepancies as the year progresses. Again, no radical distinction between the EU and the UK, but some subtle discrepancies, and perhaps the UK will declare some jurisdictions adequate before the EU does so in the next few months.
Always fascinating. Safe travels to Peru. Gabriela Zanfa Fortuna and some of our team will be there. So if any of our listeners are there, look for Eduardo, look for Gabriela. Thank you for catching us up. I guess we should encourage people who are interested in this issue. There is a comment period now, and you can file, or you can hire a Hogan to help you file and explain the process and help you write a good letter. It's a informal process. I think you can just write your opinion and tell them why you think the interpretation should be more flexible. So definitely encourage people, or if you disagree also, please pipe up and share your opinion with the EDPB. I think it goes through March. It might be soon. Check at the EDPB site. It might be soon. I'll post in the comments when the end of the deadlines are. Thank you for catching up with me, and hope to cross paths pretty soon with you and others on the Hogan Lovells team.
Thank you.
Have a great weekend.
All the best.